I'm not a lawyer, but there's a new sheriff or judge in town for the YSL RICO trial, and child, she ain't playing with y'all. The new judge, Judge Whitaker, had her first hearing today for the case, and not only did she start on time, she actually started early. Y'all, early. So she takes the bench and immediately gets to business. After doing some intros and expressing that she hasn't really been following this trial up until now.
Y'all, in a couple of weeks, I'll know all of this, but I just honestly have not been following this case up until now.
Welcome to the party. She gets into the current outstanding motions. It's important to note that today was just a status hearing, so it's really just to get an update on where things are. The defendants were not in the courtroom, so each attorney really gave a list of what motions they have open or what's pending for each of them.
Mr. Steele, on behalf of Mr. Williams, sent me yesterday a list of what he believes to be pending motions that still need a ruling. I'm just going to kind of hear from each party as to what, as the state as well, as to what y'all believe is pending that we need to get heard.
And some of those open items include motions filed by Brian Steele, the latest of which was filed yesterday, and it was to disqualify Attorney Hilton and Attorney Love from being on this case because, as he said many times now, Brian Steele plans to call them as witnesses, and he has added them to his witness list. There was another motion that was filed yesterday. It was actually a renewed motion for reconsideration of bond for Marquavius Huey. So that was another open item that was added to Judge Whitaker's list. After taking note of those items, Brian Steele comes to the podium to raise another issue. And the synopsis of the issue he's raising is that Judge Glanville should have been recused on June 12th, the day that Doug Weinstein filed the motion for recusal. But of course, Judge Glanville initially denied that motion and continued on with court. Kenneth Copeland came to the stand, he testified for a couple days, and then after all of that, Glanville finally decided to refer the recusal motion to another judge. So Brian Steele's point is that if Doug Weinstein's motion on June 12th was actually valid and the reason he was later recused, anything that happened in court after that point really should be deemed invalid. Here is Brian Steele referencing a Georgia Supreme Court opinion regarding this.
Our highest court explained that another line of appellate decisions holds that if a party files a motion to recuse a trial judge and the motion is denied, but it is later determined that the judge should have been disqualified to act in the case, all proceedings after the filing of the motion to recuse are invalid and have no effect. And the reason I raise that, the way I understand the case law, is everything that happened after the filing by Mr. Weinstein on June 12, 2024 is invalid. I just want you to know that there was a witness testifying. That's why I thought it's important, which will potentially, if you determine it, require the jury to have their notes, if you require it taken away, and then wiping out what they heard. I just want you to be aware of that.
Okay, I'm not sure if I follow what you're saying now.
So there was a witness testifying. His name's Mr. Copeland.
Yeah.
After Judge Glanville denied that motion, the jury heard from a witness on the afternoon of of June 12th, June 13th, June 14th, and then June 17th. So I just want you to be aware.
All right, I understand what you're saying now. All right, thank you.
So Steele is going to file a written motion on this issue, and then we'll see what Judge Whitaker has to say about it. Next up, Max Shart raises some concerns he has about Kenneth Copeland's testimony. And his point kind of connects to Brian Steele's point, which is that after Judge Glanville denied the motion for recusal, he made some rulings regarding the admissibility of Kenneth Copeland's testimony. And so Max Shart is saying, since those rulings were made after that recusal motion, those should also be deemed invalid, and Judge Whitaker should make some rulings on those.
I think that we need to have a hearing regarding the admissibility of his testimony. I'm not looking at Mr. Steele's motion, but I too believe that we need to look at the co-conspirator exception to the hearsay rule and determine if that applies to the gentleman who is currently on the stand. And additionally, after Mr. Weinstein's recusal motion, we spent a significant amount of time going back and forth about prior statements and redacting prior statements. go through that process again because that was done after the Mr. Weinstein's recusal motion. So we probably need to relitigate that as well.
All right. I am not going to go back. I mean, this case has been going on for how long? 6 months, at least the trial part of it. And obviously I'm parachuting in and I'm just going to have to pick up from here and move forward. I cannot go back and reconsider every evidentiary ruling that's already been made. And I don't think that's what you're asking. I think you're saying because this witness is still on the stand.
From there, Judge Whitaker takes up scheduling. She wants any new motions that are going to be filed by Tuesday, July 23rd. And then she's giving the state until Friday, July 26th to respond to the motions.
I'd like y'all to get anything that you're going to filed by the 23rd, which is next Tuesday. That may make for busy weekends for y'all, but that is what it is. And then I want responses from the state by that Friday, the 26th. Okay. And then we'll probably spend the week of the 29th we'll all be here without the jury trying to get as much done as possible, I think.
From there, Judge Whitaker goes over housekeeping. Spoiler alert, it is very different than how Judge Glanville ran his courtroom.
With regard to kind of further in the future, just when we're going to be having trial, I think it's maybe been like 4.5 days a week or something. I don't know. I guess it doesn't matter what it has been. Here's what I'm thinking. I am thinking that when we are in trial, we start at 8:45 and go to about 6, at least until the time changes and it gets dark early. All 5 days. It may be that we want to, break at lunchtime on Fridays. And if we have other business to do, we stay for the afternoon. And we may not start August 5th with the jury. We may have so much left to do still that we give them another week. But once we do start back with the jury, I'm thinking 8:45 to 6. And when I say 8:45, I mean 8:45. I intend to take the bench at 8:45. I expect I know that the parties, the defendants will be here because the sheriff's office will have them here. I want all the attorneys to be here as well. And if you have 5 attorneys on your side, as long as one of them's here, we're going forward. Okay? So I don't want to be waiting around till 9:30 to get started. 8:45. Food in court. Everybody can have water whenever they want to. The attorneys can have, whatever drink they want to, as long as you're not klutzy like me and don't spill it all over everything. I guess if you do, that'll be your problem. But snacking while trial's going on, we're not going to be doing that, okay? Not while somebody's on the stand testifying, okay? We're not at a movie. We're not going to be eating popcorn. All right. Apparently, one of the first things that I don't know how many different deputies told me was the clothing for the clients has gotten a little out of hand in terms of how much they all have now. I don't know, but y'all need to maybe get together and let's exchange most of that. And sure, they can have new outfits for court, but it sounds like they're like full wardrobes full of clothing. Let's make sure that it gets whittled down to a manageable amount of clothing, though y'all need to clear out apparently the closets. So now I've done that. Next topic, minimizing disruptions in court. I don't exactly know what that means yet, but let's try to conduct court in a way that minimizes disruptions, and we'll just leave it at that for now. The defendants listening through earpods to things on laptops while court is going on. So can somebody kind of explain to me what that's about?
I think it was originally to combat boredom.
All right. Well, we won't be bored from here on out. So then if that's the only reason for it, I want to be moving forward efficiently and expeditiously. So let's just plan to not have that happen anymore. And if there arises some new reason for it, then we can address it again anew, okay? I would like to find out from kind of everybody how many witnesses there are to go and what you expect those witnesses to say.
Yes, girl, address this.
Where are we really? Maybe like what counts they go to and what you expect those witnesses to say generally, broadly. Because this case has been going on for a really long time. And there is a rule that lets me exclude cumulative evidence. And I might end up using that. So how about y'all give me a heads up on all of that, okay?
Please use it. Please use it. We are begging you. Please use it.
And if that is something that y'all could have to me by next Friday for everybody, that would be great.
And then she addresses tempers flaring in the courtroom.
The little bit I have seen about this case, it definitely has appeared that there have been times that tempers have flared a whole lot and that people have been maybe less than professional. And I hope that this kind of breather has given everybody a breather, and everybody has been absolutely wonderful here today. But I would like for us to maintain a degree of decorum and dignity and professionalism. That is what is really expected of all of us as members of the bar. I don't want to have to say anything beyond that, okay? But if it gets to a point where I think that is not being carried out appropriately, we're going to all have to talk, okay?
And immediately after that, we got a reminder of why tempers have flared in this courtroom at one point or another. And it has to do with evidence and reports being turned over or not being turned over.
I'd like to say I'm sure that all of the evidence has been exchanged by now. Would I be correct in saying that?
There's reports that we're still missing. The state has said that they don't have those reports. Officers have testified that they wrote the reports.
Okay.
And we're still missing them.
All right.
That's been a recurring theme.
All right. If everybody wants to detail anything that they think is missing, and I'll hear from the state on whether it is either missing, about to show up, or does not exist, that'll be something we can take up substantively, just so we start out all on the same page.
Judge, I just wanted to make clear that the state has complied with its discovery obligations, that we have turned over all of the discovery that exists in this case. And as the court is aware, discovery is that which we have so we have turned that over, and we've actually gotten and requested, we've sought from outside our office any other materials that existed in the universe. We will do as the court has instructed and provide to the court a list of matters we believe have been unaddressed still as they pertain to our requests for reciprocal discovery.
Okay. And Mr. Shard, I know you've been in my courtroom before, and typically I have, one side or the other list out specifically what they think is missing, and we inquire about it and try to get to the bottom of it. So that's what we will do. Y'all make up the list, and then we will do that. We'll actually go through it in detail so that everybody knows what's going on and we all are on the same page. The next thing I want to raise, and I have no idea what has happened before now, but I would like to encourage everybody, while we are kind of in this pause, to talk to each other about whether there are any plea negotiations that might be fruitful, whether there is any room for movement by anybody on anything, any plea. I mean, I'm willing to entertain any kind of plea at any time. It can be a joint recommendation. It will be non-negotiated since we're in the middle of a trial, but it can certainly be a joint recommendation, or it can be state wants this, defense wants that. Or it can be, we all want to keep going with this trial. I am here to give everybody a fair trial and everybody a fair shake, follow the law. But I invite during this pause, if y'all want to think about that and talk about that, now would be a good time to do that.
So the takeaways. Judge Whitaker does not plan on revisiting all of the prior rulings by Judge Glanville. She's really going to be focusing on any future issues and possibly in current ones that were done after that initial recusal motion. We have to see what she says. So the next date will be July 30th. Everyone but the jurors will be back in session at 8:45, bright and early. And I have a feeling this is going to be a very different case than it's been for the last 18 months.
All right, so I'll plan to see everybody bright and early at 8:45 on Tuesday, July 30th.
Before I go, let me leave you with one more comment from Judge Whitaker. That tickled me.
I mean, if this had been my trial from the get-go, we'd have litigated all the motions to suppress by now. Motions to suppress shouldn't really be getting filed mid-trial.